The Revised Penal Code, Crimes Against Person, Chapter 2, Physical Injuries, Article 262, Mutilation. The penalty of reclusion temporal to reclusion perpetua shall be imposed upon any person who shall intentionally mutilate another by depriving him, either totally or partially, of some essential organ of reproduction. Any other intentional mutilation shall be punished by prison mayor in its medium and maximum periods. Note: under Section 10 of R8 7610, the penalty for other intentional mutilation if the victim is under 12 years of age is reclusion perpetua. Article 262, Serious Physical Injuries. Any person who shall wound, beat, or assault another shall be guilty of the crime of serious physical injuries and shall suffer 1. The penalty of prison mayor if, in consequence of the physical injuries inflicted, the injured person shall become insane, imbecile, impotent, or blind. 2. The penalty of prison correctional in its medium and maximum periods if, in consequence of the physical injuries inflicted, the person injured shall have lost the use of speech or of the power to hear or to smell, or shall have loss of an eye, a hand, a foot, an arm, or a leg, or shall have lost the use of any such member, or shall have become incapacitated for the work in which he was therefore habitually engaged. 3. The penalty of prison correctional in its minimum and medium periods if, in consequence of the physical injuries inflicted, the person injured shall have become deformed, or shall have lost any part of his body, or shall have lost the use thereof, or shall have been ill or incapacitated for the performance of the work in which he was habitually engaged for the period of more than 90 days. 4. The penalty of arresto mayor in its maximum period to prison correctional in its minimum period if the physical injuries inflicted shall have caused the illness or incapacity for labor of the injured person for more than 30 days. If the offense shall have been committed against any of the person enumerated in Article 246, with attendance of any of the circumstances mentioned in Article 248, the case covered by subdivision number 1 of this article shall be punished by reclusion temporal in its medium and maximum periods. The case covered by subdivision number 2 by prison correctional in its maximum period to prison mayor in its minimum period. The case covered by subdivision number 3 by prison correctional in its medium and maximum periods. And the case covered by subdivision number 4 by prison correctional in its minimum periods and medium periods. The provision of the preceding paragraph shall not be applicable to a parent who shall inflict injuries upon his child by excessive chastisement. Note: under Section 10 of RA 7610, the penalty for serious physical injuries if the victim is under 12 years old is reclusion perpetua. Article 264. Administering injurious substance or beverage. The penalties established by the next preceding article shall be applicable in the respective case to any person who, without intent to kill, shall inflict upon another any serious physical injury by knowingly administering to him any injurious substances or beverage, or by taking advantage of his weakness of mind and credibility. Credulity rather. 263 5. Less serious physical injuries. Any person who shall inflict upon another physical injuries not described in the preceding articles, but which shall incapacitate the offended party for labor for 10 days or more, or shall require medical assistance for the same period, shall be guilty of less serious physical injuries and shall suffer the penalty of arresto mayor. Whenever less serious physical injuries shall have been inflicted with the manifest intent to insult or offend the injured person or another circumstances, adding ignominy to the offense. In addition to the penalty of arresto mayor, a fine not exceeding 50,000 shall be imposed. Any less serious physical injuries inflicted upon offender's parents, ascendants, guardians, curators, teachers, or person of rank, or persons in authority shall be punished by prison correctional in its minimum and medium periods, provided that in the case of person in authority, the deed does not constitute the crime of assault upon such person. Article 266. Slight physical injuries and maltreatment. The crime of slight physical injuries shall be punished 1. By arresto menor, when the offender has inflicted physical injuries which shall incapacitate the offended party for labor for 1 to 9 days or shall require medical attendance during the same period. 2. By arresto menor or a fine not exceeding 40,000 pesos and censure when the offender has caused physical injuries which do not prevent the offended party from engaging in his habitual work nor require medical attention. 3. By arresto menor in its minimum period or a fine not exceeding 5,000 pesos when the offender shall ill-treat another by deed without causing any injury. Chapter 3, Rape. Article 266A, Rape when and how committed. Rape is committed 1. By a man who shall have carnal knowledge of a woman under any of the following circumstances. A. Through force, threat, or intimidation. B. When the offended party is deprived of reason or is otherwise unconscious. C. By means of fraudulent machination or grave abuse of authority. D. When the offended party is under 12 years of age or is demented, even though none of the circumstances mentioned above be present. 2. By any person who, under any of the circumstances mentioned in paragraph 1 hereof, shall commit an act of sexual assault by inserting his penis into another person's mouth or anal orifice, or any instrument or object into the genital or anal orifice of another person. Article 266B, Penalties. Rape under paragraph 1 of the next preceding article shall be punished by reclusion perpetua. Whenever the rape is committed with the use of a deadly weapon or by 2 or more persons, the penalty shall be reclusion perpetua to death. When by reason on the occasion of the rape, the victim has become insane, the penalty shall be reclusion perpetua to death. When the rape is attempted and a homicide is committed by reason or on the occasion thereof, the penalty shall be reclusion perpetua to death. When by reason or on the occasion of the rape, homicide is committed, the penalty shall be death. The death penalty shall also be imposed if the crime of rape is committed with any of the following aggravating qualifying circumstances. 1. When the victim is under 18 years of age and the offender is a parent, ascendant, step-parent, guardian, relative by consanguinity or affinity within the third civil degree, or the common law spouse of the parent of the victim. 2. When the victim is under the custody of the police or military authorities or any law enforcement or penal institution. 3. When the rape is committed in full view of the spouse, parent, or any of the children or other relatives within the third civil degree of consanguinity. 4. When the victim is a religious engaged in a legitimate religious vocation or calling and is personally known to be such by the offender before at the time before or at the time of the commission of the crime. 5. When the victim is a child below 7 years old. 6. When the offender knows that he is inflicted with human immunodeficiency virus or HIV, acquired immune deficiency syndrome or AIDS, or any other sexually transmissible disease, and the virus or disease is transmitted to the victim. 7. When committed by any member of the Armed Forces of the Philippines or paramilitary units thereof, or the Philippine National Police or any law enforcement agency or penal institution, when the offender took advantage of his position to facilitate the commission of the crime. 8. When by reason or on the occasion of the rape, the victim has suffered permanent physical mutilation or disability. 9. When the offender knew of the pregnancy of the offended party at the time of the commission of the crime. 10. When the offender knew of the mental disability, emotional disorder, and or physical handicap of the offended party at the time of the commission of the crime. Rape under paragraph 2 of the next preceding article shall be punished by prison mayor. Whenever the rape is committed with the use of the deadly weapon or by two or more persons, the penalty shall be prison mayor to reclusion temporal. When the rape is attempted and a homicide is committed by reason or on the occasion thereof, the penalty shall be reclusion temporal to reclusion perpetua. When by reason or on the occasion of the rape, homicide is committed, the penalty shall be reclusion perpetua. Reclusion temporal shall also be imposed if the rape is committed by any of the 10 aggravating qualifying circumstances mentioned in this article. Article 266, letter C, effect of pardon. The subsequent valid marriage between the offender and the offended party shall extinguish the criminal action or the penalty imposed. In case it is the legal husband who is the offender, the subsequent forgiveness of the wife as the offended party shall extinguish the criminal action or the penalty, provided that the crime shall not be extinguished or the penalty shall not be abated if the marriage be void ab initio. Article 266d, Presumptions. Any physical overt act manifesting resistance against the act of rape in any degree from the offended party or where the offended party is so situated as to render him incapable of giving valid consent may be accepted as evidence in the prosecution of the acts punished under Article 266A.